Welcome everyone to Litigating Despite COVID-19 for April 23rd, 2020. I am Mike Kelleher from the Litigation Section of the California Lawyers Association, and I am joined today by George Wailes, the chair of the Litigation Section, and Adrianette Ciccione, a member of the litigation section, and we will also have a recording today from Michelle Galloway providing tips on remote hearings. So let's go ahead and get started. George, you ready to go?
Sure. Welcome. I'm George Wailes, as Mike said, the chair of the Executive Committee of the Litigation Section of the California Bar Association. This is one of the ways we're trying to keep you informed of what's happening during the pandemic. We also are setting up periodic updates, and we urge you to check the website. Today, I'd like to talk about a presentation that the Bar Association of San Francisco and California Lawyers Association sponsored earlier this week with the San Francisco County Superior Court. Presiding Judge Gerald Wong and Assistant Presiding Judge Fang provided an overview of the status of the operations of San Francisco County Superior Court. It was an hour-and-a-half presentation and extremely informative. I'm just going to go over some highlights of what they presented. First, there were some primary points that were emphasized throughout the presentation. First, everything is fluid. Judge Wong pointed out that Emergency Rules 12 and 13 were just adopted by the Judicial Council. We actually sent out an email about that earlier today, those new emergency rules. And so he said the court was going to need to adopt some orders to implement those rules. And he urged everybody to check the website, the court's website, and the Judicial Council's website constantly, at least daily, to keep updated on what's happening. I would add to what Judge Wong said, check the CLA's website because it has resources that Adrianette is going to mention that are for all courts in California. The second thing Judge Wong emphasized is the court is open for business, but it's really open only for essential services, urgent matters, criminal, family law, probate, civil, complex litigation. He will go into specifics in a minute, but he emphasized that it's really the urgent matters. And the next point talked about what to do because of the fact that the court is only open for urgent matter. The next point was work with opposing counsel. Try and avoid coming to court. Try and avoid needing to appear on discovery matters or trial continuance matters or any disputes you have. If you can't work out a new schedule with opposing counsel or arrange to solve the discovery dispute, if you make applications to the court, you need to make sure that those applications contain admissible evidence. Judge Wong and Judge Fang both mentioned that there were a lot of declarations coming in based entirely on hearsay. And they emphasize that you want to make any application to the court the same as it would be without the pandemic, with admissible evidence and with facts demonstrating that the pandemic has substantially interfered in your ability to do whatever you are asking the court to change. Now, there was a lot of time spent on specific departments. I'm going to summarize what Judge Wong and Judge Fang told us about the specific departments. The criminal courts are hearing arraignments and release calendars. Next week, they're actually going to start hearing preliminary hearings. Probate. Probate is working only on the LPS calendars, including temporary conservatorships and urgent ex partes. Family law. Family law is hearing delinquency, dependency, DVRO and TRO matters. Again, only the urgently needed hearings. The civil courts are still open. Judge Wong's presiding judge's calendar is all by court call. He has the trial call on Monday, so if you had a trial that was scheduled that has been continued, make sure you show up for the trial call to hear the new trial date. His law and motion calendar is still being heard on Tuesdays and Thursdays, and trial objections are being heard on Wednesdays. Again, all the ex partes in front of him and all the appearances for his regular calendars are by court call. The Real Property and Housing Court, of course, the Chief Justice has the Judicial Council stayed all unlawful detainers, except the court is still hearing the exceptions for public safety and health. So if you have that type of case, you're supposed to contact the court and apply to have a hearing. Law and motion, they are still hearing ex parte motions. Also, Judge Wong mentioned that if a hearing was completely briefed, even though all hearings have been taken off calendar, you can ask the court to hear a fully briefed hearing by asking the court, and then it would be a court call appearance. So if the motion was completely briefed before it was taken off calendar, you can ask, and the Judge Schomer, Judge Ulmer, law and motion judges will decide whether to hear it. The asbestos court is looking at the cases that are entitled to priority for when they open back up after the pandemic. The court has come up with an innovative voluntary settlement conference procedure so that during the pandemic, you can work with the court. They'll provide a judge to hear the settlement conference, and you can ask the court to set one of these voluntary settlement conferences by emailing Elizabeth Kelber. She is at ekelber@sftc.org. That's Elizabeth E. Kelber, Kelber, @sftc.org. So why not take advantage of this time, Judges Wong and Fang said, and have a settlement conference. Another major issue they covered were trials. All trials have been continued 60 days for civil. And they expect that the new trial date will be exactly 60 days after Judge Wong said it would be the Monday that comes either before or after that 60 days. So if 60 days falls on a Wednesday, he would set it on the Monday. You will get a notice from the court about the new trial date, but it'd be better if you show up on the date your trial was originally scheduled for the trial calendar, and you'll hear it then. The court is going to prioritize when it reopens a series of trials entitled to priority. Criminal trials, of course, unlawful detainers, those that have preference reasons, that have preference motions filed, 5-year statute cases, and of course, domestic violence restraining orders and temporary restraining orders. The court's dealing with the difficult issue that a number of courts have identified, and that is, what do you do with jurors? The jury assembly room the jury assembly has to be reorganized. Voir dire has to be reconfigured. Judge Wong even mentioned that approaching the bench won't be the same. So, in short, what the panel informed us was that San Francisco Superior Court is open for urgent matters, that we should try and work with opposing counsel rather than approaching the court if need be, that our trials are automatically continued exactly 60 days, plus or minus whatever day in the week it falls, but that we'll be getting notices of the new trial date. And that if we make applications to the court, we should make sure that we demonstrate how the pandemic substantially interfered. He cited Government Code Section 68115, subsection A4, for that citation, which deals with how the courts can deal with problems or disasters such as epidemics. So you might want to look at Government Code Section 68115, especially subsection A4, if you're going to make an application to the court. So stay safe and sane during these pandemic times. You might consider volunteering for one of the litigation section's committees. The applications are on our website and are due May 15th. Or consider presenting a webinar or writing an article to help your colleagues during the pandemic or on a topic of interest to all of us. Mike, I'll turn it back to you or directly to Adrianette.
Great, thank you very much, George. Yeah, I was in San Francisco Superior Court on a trial the day the shelter-at-home order came out, and it came out like at noon that day, and I was trial teching for a trial before Judge Harold Kahn, and we had been going the week before, and things were starting to build, and Monday we all showed up. The San Francisco Superior Court had only allowed trials that were ongoing. No new trials were starting, but because we were already there, the court had us go ahead. So in the morning when I came in, I rearranged, we had video and all we were showing to the jurors. So we rearranged it all so that the jurors were not sitting in the jury box any longer, but we spread them out throughout the gallery. And then we found a different place to mount the screen. And, so I was kind of sitting next to or 6 feet away, but closer to the jurors than I usually sit. But it was a very strange and weird day, and I can tell you that San Francisco Superior Courts, it is difficult to put 12 jurors all 6 feet apart and still figure out how they're going to be able to see stuff and participate and the like. It will take some changes. Okay, great. Thanks very much. I think we'll go now to the recording that we have with Michelle Galloway from the litigation section. Last week she appeared and gave us some tips on remote hearings, and she is back with more tips today in a recording. So let me get that started for you, and that'll be about 7 minutes, and then we'll come back and have a summary from Adrianette Ciccone about the changes in the emergency rules recently. So here we go with Michelle Galloway.
Well, welcome back. This week I was going to share a few more tips that are coming out of various hearings and civil trials to give you an overall sense of some of the things that we see happening. The first is that last week we talked about the importance of lawyers dressing for court, even if your hearing is going to be by video conference. This week I wanted to add sort of the aspect of public participation in the judicial process. A judge in Atlanta federal court was attempting to conduct a hearing and let the public listen to the hearing. Unfortunately, a number of people did not mute their lines, which was difficult enough, but several of them also put them on hold, which resulted in music being played for everybody who were trying to conduct the hearing. So just a couple of pointers. One is that even when you are in meetings, we now work from home. It's important sometimes to be able to mute because things are happening in our homes with pets, children. Please remember it's mute, not hold, because when you use hold, you can send everybody off into music, and then everyone has to disconnect and reconnect to be able to continue on with the meeting that they're having. And obviously that will be something that we'll need to think about in the context of hearings where that same issue is at least coming up. So use mute, that's your friend, not hold. The second area that I wanted to raise is a number of courts have decided not to have hearings, or they've postponed hearings and are planning to just rule on the briefs. And I was intrigued by a recent decision by the Federal Circuit who had been approached by one of the law firms who said, we had a diverse candidate lined up to make this argument. Would you please put at least the telephonic hearing back on calendar? And the Federal Circuit has done that. And that's something that we've seen in a number, at least federal courts, where judges have issued orders encouraging parties to send diverse or young attorneys to argue motions. And that's just one that even in the current environment where we can't be there in person, there are still opportunities that are being provided. And so I think important for us all to keep that in mind as we continue diversity and inclusion efforts during this time of upheaval in the legal area. The third area that I wanted to just mention was there's been video conferencing available to many people, but it's interesting in some of the ways we're seeing it used. And one of the interesting things coming out of the district court in the Northern District of California has been a magistrate judge encouraging the two parties to meet via video conference. The suggestion was every other day, as opposed to sending emails and letters. And so not only did the court suggest to the parties that they should do that as a every other day tool, but that magistrate has also said they will continue to conduct a status conference on discovery matters every other week during that. Some of you may recall that was something discussed by our judicial panel at the 2019 Litigation Summit. So you can certainly go back through our online portal and find that if you'd like to hear from a number of judges their perspectives on ways to handle status conferences and other issues in litigation. And we'll, I'm sure, see similar topics touched on by our judicial panel at our summit this fall. And then finally, one of the other things is judges who are turning to what do we do about trials that were either underway when the shelter-in-place orders began, and certainly thinking ahead to a time when we would be ready to resume jury trials. And so once again, here in California federal court, there was a trial that was started in early March. It was then adjourned when the first shelter-in-place went into effect. And now the judge and the parties have been working on creating a further voir dire or questionnaire for the jurors about their feelings about returning to continue the trial, but also what kinds of protocols could be put in place that would allow that to happen effectively. The CLA team, we're continuing to monitor that. You can find additional resources on our CLA page and our COVID-19 resource page. And we are planning at least 2 upcoming seminars from the litigation section that will include how to conduct remote depositions with a number of ideas from practitioners who are doing those right now, as well as further thoughts and information from both the bench and lawyers about the use of video conferencing technology for hearings, remote hearings, and then the possibility of using that in jury work. So those were some of this week's updates of things that are happening in this new world where we're going remote online. And I also thought I would give you sort of an ethics minute. Pennsylvania issued an advisory opinion that deals with a number of issues related to ethics with an emphasis on sort of a work from home environment. So there are many ethics opinions that are out that talk about various aspects of using technology as a lawyer. The Pennsylvania opinion was issued after most of the country was put under shelter-in-place orders, so it specifically refers to working at home. And one of the areas that I thought was of particular note was that it cautioned about the use of or having in your vicinity at home any kind of personal voice assistant. And the concern was, as they explained, under sort of what are the considerations that will be taken into account in deciding whether you were reasonable and the precautions you were taking to avoid disseminating or inadvertently disseminating confidential or privileged information, that you should be in a location for your conversations where you should try to be not overheard. Again, there will be difficulties with that depending on some people's particular situations, but did you take reasonable precautions? but it also specifically called out using smart devices such as the Alexa or Google Voice assistants in locations where you're having various client-related phone calls. And so that's certainly something that as we work from home, you may want to take into account. And again, we have a number of online ethics programs and programs that will be coming up. So one of the great things is to always monitor your email updates that you get from the CLA litigation section and be checking our resource page for more information.
Okay, we're back. That was Michelle Galloway. Oh, hold on just 1 second here. All right, we're back now. That was Michelle Galloway giving us those tips on remote hearings. And now I'm going to turn it over to you, Adrianette, if you can give us your presentation on the changes to the emergency rules.
Absolutely. Good afternoon, everyone, and thank you all for tuning in with us. I want to personally thank our chair, George, and our amazing rock star. Well, both of them, everyone's a rock star, but Mike for all of his help and support with all the technology here. My name is Adrianette Ciccone, and I will be discussing the updates that the Judicial Council of California added within the past week. These updates are on the Judicial Council of California website, and they can also be found on the CLA website. So please be sure to check either of those, but I definitely will always plug the CLA website for changes. There's a lot of changes that are happening, and CLA is really doing a remarkable job at keeping up. And with that, I will be updating providing updates on Rules 8, 12, and 13. So Emergency Rule 8, which eliminates the automatic extension of protective and restraining orders, came down this past week and now requires courts to offer applicants a new way to renew their orders. So again, it applies to emergency protective orders, temporary restraining orders, or criminal protective orders that were requested, issued, or set to expire during the current state of emergency. And it also includes orders for custody modifications, visitation, and those pursuant to Family Code Section 6221. Any emergency order made pursuant to Family Code 6250 that was issued during the current state of emergency must remain in effect for 30 days from the date of issue. For temporary restraining orders or gun violence emergency protective orders issued or set to expire during the state of emergency, those must remain in effect for a time period the court determines sufficient to set up a hearing for the long-term order to occur or for up to 90 days. Any criminal protective order set to expire during the state of emergency must be automatically extended for 90 days or whenever the matter can be heard, whichever is first. Upon filing of the request to renew a restraining order after a hearing is set to expire during the current state of emergency, the current restraining order after hearing must remain in effect until a renewal hearing can occur or for up to 90 days from the date of expiration. Now, in terms of ex parte requests and requests to renew restraining orders, the courts must provide a means for filing of these documents. And again, they are TROs and requests to renew restraining orders. The courts can do this a number of ways. They can provide a physical location, they can provide a drop box, or they can allow for electronic service. An ex parte request and a request to renew a restraining order may also include an electronic signature by a party or that party's attorney. Parts 8D and 8C are going to remain the same. And just to refresh your memory, if for 8D, if a respondent appears at a hearing outside of an in-court appearance, meaning by phone or by Zoom, what have you, and the court grants an order, no further services required upon the respondent for enforcement of the order as long as Family Code 6384 is followed. Last, orders issued by the court to modify the duration or expiration date of orders subject to this rule must be transmitted to the Department of Justice via something that I had never heard of. The acronym is called CLETS, per Family Code 6380, whenever they are issued, whether it's issued on a judicial California counsel form or in another format. So that's my update for Rule 8. That was a lot. Again, please check out the specifics of the rule on the CLA website. The rule is also available at the Judicial Council of California website. Moving on to Rule number 12, or Emergency Rule number 12, I'm sorry. This rule requires attorneys to electronically serve and receive all notices and documents in all general civil, family, and probate cases if requested to do so by the other party. Note that Rule 12 does not apply in cases where parties are already required to provide or accept notice electronically, and is not intended to prohibit electronic service in cases that are not addressed in the rule. So in practice, what this means is that electronic service is voluntary for self-represented parties, and the rule does not apply to small claims proceedings, unlawful detainer proceedings, and petitions to prevent civil harassment, elder abuse, and workplace violence. So how is this done? If a party who has already appeared in a case would like to get the other attorney to accept e-service via of a notice or a document, and note that service is normally done by mail, express mail, fax, etc., right? So prior to the new application of electronic service, the serving party must confirm by phone or email the appropriate address for the attorney being served. All right, so that's the first thing. So one, you want to get the appropriate email address. Next, you have to go to the, after obtaining the consent, you must go to that attorney and give them, along with the document, a copy of this rule, which is Rule 12. And you must electronically serve the requesting party the notice or the document that would normally be sent by the traditional means of mail, express mail, fax, etc. Note that Emergency Rule 12C says that e-service is only permitted with the consent of the party, which is confirmed in writing. This writing can be done via email or regular mail. And now what's important for all of us that do civil litigation is the time. So the time of the electronic service that is going to be applied for your notice or your document is going to go to general civil cases and family cases that would be pursuant to CCP 1010, Section 6A4 and Section 6A5. For probate cases, you want to look at the time of service at probate section 1215C2. So if you have documents that are confidential or sealed, those documents must be sent electronically encrypted. I know I've received some e-service documents that were encrypted, and I've never sent them on my own, but the opposing counsel sent them using another type of software. So if you have that, you want to get that in order. This rule is going to be effective until 90 days after the governor declares the state of emergency is over, or until the Judicial Council of California says otherwise. So again, this relates to Rule 12 relating to electronic service. And in order to get the pass in sending documents electronically, you have to obtain written consent from the person that you would like to serve, and this would be for notice or documents that would be be traditionally served via mail, fax, etc. All right, moving on to rule number 13. So emergency rule number 13 allows courts to, in essence, backdate the modification of support orders to the date the application was served on the responding party rather than the date it was filed with the court, which is also important. The purpose behind this was to accommodate the difficulty that some parties were having with filing documents with courts as they are understaffed. So what sort of cases does emergency rule number 13 apply to? I'm glad you guys asked. It applies to requests to modify, terminate child, spousal, marital support. And for details on the specific cases, you want to check the family code. The date for the filing of these is going to be effective as of the date and request papers are mailed or served on the party or the attorney when allowed. And the cases that are not going to be subject to this rule are those that are found in Family Code 3653B. So if you deal with any of those cases, this rule is not going to apply to you. In terms of service, again, this is what I found to be the most interesting about this one. So if the request and the moving papers, the supporting papers have not been filed with the court, the moving party must serve the documents after filed with the court on the other party or their attorney. And here's what's interesting. If the moving party is the child support agency and they have an unfiled request with a valid court date and time, service to the child support agency is not required. So you'll be able to save a little bit of time if the child support agency is the moving party. Note that the court retains jurisdiction pursuant to codes 5.92 and 5.60. And this remains, or Rule 13, Emergency Rule 13 remains in effect 90 days after the state of emergency has been lifted or until the Judicial Council of California otherwise repeals it. And that concludes my presentation.
Thank you, Adrianette.
Sure.
George, do you have any closing comments here before we go?
Well, please check the webinars, the dates of the webinars that we have coming up in the next week or two, specifically related to coronavirus, as well as webinars we're going to be putting on over the next month or so. But again, stay safe, retain your sense of humor and your sanity, and consider volunteering. Our committees are a great way to get involved with the litigation section. A lot of dedicated volunteers doing good for California attorneys and Californians in general. And you can also write an article or do a webinar. Thanks for attending. We look forward to seeing you next Thursday.
And I'll follow up a little bit on George's comment and specific in the notes to this webinar. You'll see links to all the rules that Adrianette was discussing. And as to webinars, there's a three-part series going on about how to try to resolve a case in mediation using remote technology tools. And parts 1 and 2 have taken place already and are recorded and will be available on the CLA website. And then the third session is coming up soon. So take a look at the CLA Litigation Section website for all that information. And with that, I think we have a wrap. Goodbye, everybody. Thanks, Adrianette. Thanks, George.